All right, everybody. On behalf of Trident Title, Performance Title, and Synergy Title, we want to welcome you to Better Call Paul, the first week of school and right before the long weekend edition. So today, we are going to cover what some may think is very simple and some honestly, genuinely just have no idea. And that's why we wanted to do this topic today. So we are just going to talk about what is title insurance. So this will be a short and easy one, but I do want to just get it out there. Then allow you guys to ask any questions that you have. One thing that we see across all the different offices and all the real estate agents, no matter what brokerage you come from or who your broker is or where you work with, people usually realize that title is a part of the transaction, but they don't actually know why or how or what happened. So a couple of our topics this month are going to be focusing on that and really kind of clearing some of that up. So if you do have any questions, save them till the end, as I'm sure Paul's going to answer a lot of these things. And we'll interject a little bit with questions that we get from agents all the time. So Gab, you too, if you want to pop on at any point and, share things that you hear all the time. But Paul, give us an idea on what title insurance actually is, why we should have it. And for some of you that were on early, maybe you can explain a little bit about who chooses title insurance depending on where, kind of like what we were just talking about, but just to let everybody kind of understand totally what is title insurance, why it's important, who chooses, and all that fun stuff.
Well, title insurance is a promise from a third-party title underwriter written through a third-party title agent to the buyer and to the lender, promising them that title has properly passed to the buyer and the first lien is properly recorded in favor of the lender. And that's the principle of the transaction. Nobody trusts anybody in this world, and the only reason you are doing the transaction is because you have confidence that there's this third-party underwriter that has a lot of money in escrow just to make sure they didn't make a mistake. Because after the closing, if there's a problem with title, good luck finding that seller and good luck getting your money back from that seller. What you need is a deep pocket that's promised you have good title. And that's what title insurance is at its core. The reason that John Weber and I sold our company to Fidelity National Title is they are the largest underwriter in the world. They have the largest reserves, cash reserves, of any title underwriter in the world. And if there's a problem, they can solve it. So it gives me great comfort and confidence to know that they're around, available, insuring our titles and making sure that the buyers get what they get and that the lenders get what they get, and to allow those transactions to move forward. Now, let's try to talk about what title insurance is not. Title insurance is not a promise that you can use your property for any specific use. So I get people who come back to me after closing and say, I wanted to put an extension on my house and I can't. I didn't get good title. The answer is you got great title. You just don't have the land use or the zoning right to build onto your house. So title doesn't insure for land use and zoning issues. Title doesn't insure that there are no open permits. If there are 12 open permits on the property, unless you as a realtor require contractually that the seller close out those open permits, you can pass good title from a seller to a buyer with open permits. So there are various things that title insurance does and various things that title insurance doesn't do. We'll talk a little bit more about what title insurance doesn't do. Title insurance doesn't promise that you own title to the property with no restrictions. Almost every that identify what exceptions you're taking title subject to. If it's within a homeowners association, it will include the Declaration of Protective Covenants. If it's within a condominium, it will include the Declaration of Protective Covenant, Declaration of Condominium. It includes easement rights. It includes water and sewer usage rights. It includes taxing district rights. Many different things are listed in the B2 that are common to subdivisions that are absolutely not only safe to take title, but needed for title, because you wouldn't have electric in your home without the utility easement. You wouldn't have water in your home without the water and sewer easement. You wouldn't be able to drain your toilets without the sewer easement. So there are a whole bunch of things that you want to see on the B2 exceptions to make sure that title has been properly vested with the right companies. But there are also some scary things that are sometimes listed on B2 exceptions that you're not prepared for, that can cause a real problem. And that's where you need an attorney or a seasoned title professional to review and make a determination for that buyer that you're getting the title that's important and appropriate for you. If there's an exception on there for an easement that runs through the middle of a vacant lot, it's going to be very difficult for you to build a home on 1/3 of the space of the lot. You need to make sure that that easement is moved to one of the sides of the lot in a setback requirement. But those are all things that somebody might, like myself, needs to look at, and aren't things that agents should be focused on. But again, I do want you to understand the general overall concept that title insurance says you own the property, and Schedule B2 of the commitment and Schedule B of the final policy identify all of that list of documents that you're taking title subject to.
So one question we get all the time, Paul, is do we need title insurance? Is it mandatory? Not is it optional or should we have it, but is it actually something that is mandatory in the state?
So if you're getting a loan, it's mandatory, period. No lender is allowed to lend in a Fannie Mae, Freddie Mac deal without it. Even the private lenders know that's the only way to ensure that they're secured, is to get a loan policy confirming that they're in a first lien position. And you don't want to have to run the risk of liens superseding you, non-buildable lots, all these kind of things. There are some unscrupulous sellers out there, and they'll sell you what they can sell you unless you understand what you're doing and protect yourself. So would I ever allow a client to close on a piece of property without title insurance? Never. Is it legally required? No. People are allowed to buy snake oil. I mean, it doesn't help anybody, but people buy it.
So a couple other things we always get asked. In Palm Beach, when it says that the seller chooses, or it's standard, I guess it's not really required, but it says it's standard that the seller chooses title insurance. What are they actually choosing? What are they paying? How does that compare to Broward, Dade, Martin, when the buyer chooses and they're paying? Can you just kind of break that down a little bit?
Sure. The question of who pays and who doesn't pay is a bit secondary to whether there should be title insurance. Again, if you're representing a buyer and the seller says, well, you don't need title insurance, that's the first moment in the world to buy title insurance. The seller's got a problem if that's what they're suggesting to you. And again, sellers are gone. Once the closing happens, especially in the state of Florida, even if you find that seller, even if you get a judgment against them because they sold you a lot that's not buildable, or they sold you a lot that had liens on it, even if you get a judgment against them, mostly it's good to use as wallpaper. Very few times in the state of Florida do people ever collect on a judgment. So I don't think that you should go forward with a transaction without title insurance. Now, the difference between Dade, Broward, Martin County, and Palm Beach County is one of the few counties that the seller selects the title. There's an old wives' tale that it happened in Palm Beach County because the courthouse burnt down and all the records were lost, and the buyers weren't comfortable buying unless they got title insurance. So the sellers had to start paying for the title insurance to give the buyers comfort. I don't believe that's true at all. Number one, at the time that it switched, we shared a courthouse with Dade County, and we're still part of Dade County, so I don't think those are true at all. But at some point, the custom switched where the sellers paid for title insurance. And today, if you were doing a deal and the seller turned around and said, okay, well, I'll accept your purchase price, but the buyer needs to pay for title insurance, a shrewd buyer, a shrewd negotiator is going to say, fine, I'll pay for the title insurance, but if the title insurance costs $5,000, I'm going to reduce my offer by another $5,000. I'm not going to pay for the title insurance and match your price. So in my opinion, if you had a perfect world, the buyer would pick the title agent. That's what I would want in a perfect world, because if I'm buying a house, I would want to pick a title agent who was competent, and I had confidence that they were going to do the right thing at the right time, had experience. You know, when we sold the title company in 2009, we saw all these title people who had been out of work for 3-4 years. Sorry, we sold in 2016. We started in 2009. But the point was, in 2009, when we were growing, all these people who were out of work from other title companies, we were able to pick the best of the best. And we were able to surround ourselves with really great quality closers. And by the time other people started opening up title shops in 2014, 2015, 2016, because the economy was humming again and they thought it was a good business to be in, you weren't getting the best quality people anymore. And you were getting people who may not have the 15 years or 20 years of experience that our closers have. Those are some really important distinctions. And when you're a seller, other than going on the recommendation from your broker, you're just picking on price. You're just trying to find somebody who'll do it the cheapest possible thing. I get calls from realtors all the time. Can you give me a title quote on this property? And I quote them promulgated rate, and I give them our closing fee. And I say, is your seller interested in making sure that they don't have any retained liabilities after closing? And they said, no, we couldn't care less. I just want the cheapest job for my client. And, you know, I have to joke with them and say, well, I'm happy they didn't feel that way about your services. You know, there are people who sign realty listings for 1% instead of 6%. And whether they get what they pay for is their decision. But I think it's a horrible idea to make decisions about who's going to insure your property based on price. I think you should be willing to pay a reasonable fee to a competent company to make sure it's done right. And
funny that you compare it that way, Paul, because we see that all the time, right? And really, at the end of the day, the title closing fee is actually pretty cheap compared to real estate commissions. You know, a normal real estate commission, like you said, would be 6%. And often we get people that do it for 1% on one side, 2.5% on the other side. So, you know, at a 3.5% discount or 2.5% discount. And then in our world, you know, a normal closing fee is $600 to $800, and discount ones are $100 cheaper and allow things that would never get through our world.
yeah, you know, and I've also seen, you know, I've had realtors turn back to me and say, sorry, I'm not going to use you guys anymore because I found a company who's willing to charge a $550 closing fee instead of your $750 closing fee. and then I take a look at one of their HUDs,
Yeah.
and it's a $550 closing fee, but they charge $250 for the abstracting fee. They charge a $150 wire fee. They charge $180 on top of what the actual cost is to the city of Royal Palm Beach for an estoppel letter. And, you know, they're absolutely getting gouged.
Yeah.
But they focus on the closing fee and allow people to upcharge them other places. So.
And like you said, quality. You know, we constantly have those issues where other closers or companies or title companies will do things, you know, that never get by our underwriters. And when we, you know, call them out on that, they try to go around. We've had a couple of those, just me and you together in the past month, you know, where things would never get through Fidelity and they would never insure those and back those up, and they'll go somewhere else and get insured. And then we have different quality and different things coming up that we're always worried
about. Yeah, I mean, we've had so many times now, or just recently had a guy came into town with his girlfriend and wanted to start buying homes, and went to some lenders and started saying that he was buying second homes so he could get a lower interest rate up and down the coast. And turns out the guy's married, and if it's a second home, you're supposed to have your spouse sign the mortgage. And all of a sudden he says, well, it's an investor deal. It's not a second home. And you said, well, did you tell your lender? Because your rate was based on a second home, not an investor rate. You just leave that to me. Yeah. Oh, okay, you're committing mortgage fraud. Great. Well, you know, as long as it's a second home rate, we need your spouse. Well, I don't want her to find out I'm buying a home with this girl. Okay, good luck to you. Have a great life. You know, and they found a title company who was willing to write the deal.
Always, they always do. That's what blows me away. They every one of these cases that we've ever worked on together, they find one every time.
Well, it's interesting that you say that, because on this particular one, I was upset enough to find out who the underwriter was. And I went to their underwriter and I said, I just don't understand how you're allowing these people to close these deals. They said they've closed 3 deals in the last month under these same circumstances. And will you please allow me to start writing it that way? Yeah. And the underwriter for the state said, no, absolutely not. You're not allowed to do that. And talked to that title company and said, we're going to put you on an audit. And if you ever do that again, you're closed down, which is great for that one company. But I'm sure there are 50 others who don't care and just want to pocket the fee. And what's going to happen to those people specifically is someday this wife out in wherever she was is going to find out this guy's shacking up with his girlfriend down in Florida, and she's going to be furious, and she's going to hire a divorce attorney who's going to go after him, and all of these houses are going to be part owned by her. And the title insurance company that they insured with is going to say, I'm sorry, you lied to us. We're not insuring this at all. So, you know, people think that they're getting away with something, but if you have knowledge of it and you don't tell the title company about it, and then the thing happens, you don't have any insurance. If you read the jacket coverage, you know, anything that the buyer knows of and fails to disclose, and then there's a subsequent claim on it, there's no coverage there. So,
yeah, all right, yeah. Gab, I know Gab had a couple things I wanted her to get to jump in, and then I have a couple questions too coming in. So Gab, jump on in. Give her 1 second.
Hi.
There we go.
I'll turn my video on too, now that the phone's not ringing for the moment. Let me try to remember back. So I wanted to point out that as flattering as it is for Paul to talk about B2 exceptions and say you need an attorney or an experienced title professional to help you with B2s, please mind, we cannot do anything with B2s. I can't, our closers can't, we are not allowed, we're not even allowed to tell you this means this means this, So just keep that in mind if you guys get clients. I mean, I know the mineral rights have been big lately. I just had an agent email and say, please confirm that such and such, rights have been released from B2 exceptions and that you're going to take it off, remove the exception. We have no authority to do anything like that. So, I mean, Paul, correct me if I'm wrong, but from my understanding, even as title agents, we can't, sometimes our underwriters can go in and approve us to do, certain things. It's certainly not for you guys to interpret the B2s. And really, there's a lot of things that we can't even interpret, and the buyer is going to need to hire an attorney if they want. I've sent out B2s and had people go, "Hi, can you please explain these because they're not very clear." They would need to get an attorney for something like that.
So, Gabby, thank you. Let me clarify what I was trying to say there, because it certainly came out wrong. When I'm doing a buyer representation, every single time I get a title commitment, within 5 days under the standard contract, I'm required to send a title objection letter that says, okay, at closing, I want you to do A, B, C, D, E, F, G, H, I, and a whole list of things that I want them to do, and that they are not authorized to close until they do, to protect my buyer. I agree with you. No realtor should be writing those letters. And our title agents aren't allowed to write those letters, period. What our title agents are allowed to do is look at a title policy, look at a title commitment, and see a problem. And I get calls, and Ray Suarez gets calls all the time as soon as that commitment comes in to say, whoa, wait a second, there's a probate that needed to be done. There's a claim of lien, there's a bankruptcy, there's something else, and we'll be able to address that and put you with the right people. And it may be Trident turning around saying, we can't do anything for you, you need to hire an attorney to address this, but at least they're going to do it, and at least they're going to tell you. And a bunch of these other title companies,
it just sneaks through.
Just don't do a thing, just leave it as a B2 exception. Oh, by the way, you're taking title subject to any bankruptcy rights that this person had. Well, 5 months later, that person in bankruptcy says, I want my house back. And you don't have any coverage for it because the title company didn't raise the issue and didn't think it important because they wanted to earn the $3,500 title fee and just let the deal close. So that's what I was trying to talk about when you have a licensed title professional, that they can spot something. And the other thing is, we know enough that when somebody does turn back to us and say, oh, there are mineral rights, but I want to check and make sure that the rights of entry have been released under MARTA or under some other theory, we do have underwriters that are assigned to us that we can send that question to and get a definitive answer. So that's also a big help. And our title agents aren't allowed to make that determination, but our title underwriters are. And we've really got some great ones. I test them all the time.
Gab, anything else you want to add?
The only other thing I was thinking is, I don't know if you want to do a brief overview of deed types. When you were talking about how title insurance isn't legally required, if there's no lender, but why would you not have title insurance? And just kind of get into how you're not going to get a warranty deed if you choose, like maybe get into that. You can't give us a contract and say, I want you to clear the title, but I don't need title insurance. So I was just thinking a little bit about maybe deed types and what, if you don't want title insurance, what is your client going to have to do, and what are what are they going to have to
So
deal with?
none of the title companies that we're associated with are allowed to handle a transaction if they're not issuing an owner's or a lender's policy, period. That's just the law. The only people who can try to do that for you are law firms. And I've done that twice in my 29 years of practice, and I can tell you that that both times I had my client sign a letter that said, basically, I think you're out of your mind crazy, and I'm taking no responsibility for whether or not you took good title to this property, period. Even if it's your best friend in the world, they might not know what they have. They might not know there's a problem. They're not intentionally trying to defraud you, but that still could mean you own nothing and you're giving them a sizable amount of money. So I think every transaction should have title insurance and full stop. When you're asking about deeds, I don't think deeds mean anything. I really don't. You know, people say, well, I want a warranty deed. I don't want a special warranty deed. I want a general warranty deed. Okay. Who are you getting it from? You're getting it from a husband and wife who are going to buy another homestead property somewhere else and are going to have absolutely no assets that you can collect against if they're lying to you. You know how many sociopaths we have walking around with us these days who would sell you something after they sold it 10 minutes earlier to somebody else? All it does is allow you to buy a lawsuit against these people. You're going to spend $50,000 chasing them in court. If they're a sociopath and they were defrauding you, they'll have no problem running you around for 3 years for another $50,000 in legal fees. And then when you do get your judgment, good luck collecting. So even if you get a warranty deed, it's from an individual, or worse, it's from a company that has no assets. You know, the only thing that you can sink your teeth into if there's a problem is Fidelity National Title. They've got over $500 million in reserves for claims. If there was a catastrophic event and tens of thousands of people had a full loss on their house, people are still going to be protected because they have that title insurance. They're not going to have any protection going after, you know, XYZ Corporation who built the house and sold it and, you know, didn't even started up a new company to build their next house. That's not going to give you any comfort. So I never get caught up in those warranty deeds versus special warranty deeds. If somebody offers me a quitclaim deed, you know, I get a little nervous. What do they know that I don't know yet?
But that was kind of where I was going with that, you know, if you're not going to get title insurance, in essence, you're pretty much just having someone quitclaim you the property because you're not getting any type of insurance.
Sure.
That title is clear.
Yep. Yeah, no, if you don't have a title insurance policy that's been reviewed by somebody and it's a solid policy, you might as well have taken title with a quitclaim deed because you got just as much chance of collecting from those sellers. Yep, I agree.
So that being said, we had two questions come in that kind of tie into this. So what happens if there is actually an issue with title and there is title insurance on it? So what happens? How is it resolved? How does that work?
Sure. I file about one title claim a month, probably throughout the year. That's because I'm known as a guy who solves title problems. So a lot of people come to me once they've acquired a property and there is a problem. Most of the time you file a claim. So a guy like me writes a letter to the title underwriter and says, I'm sorry to report that my client has a problem. There was no notice of an easement on this property, but we found out from Seacoast Utilities that they have an easement running down the center of the property on a combined lot, and it was never abandoned properly, and it was never noted on the title policy. So we're going to need your help in contacting Seacoast and having that easement relocated to the side of the combined parcel. And that was one that happened last month, and we've already got an agreement from the title company that they'll agree to pay for the cost of moving the drainage line from the center of the combined lots to the side of the combined lots, and properly handle the vacating of the existing easement and the relocating of the existing easement to the side lot. And they're the ones who are paying the money to Seacoast Utilities. Now it's a $1,200 application fee. It's going to be a $7,000 installation fee, and attorney's fees on top of that. So it's probably a $15,000 issue. And because the people had title insurance, it's free. That's the title underwriter's responsibility now.
Great. That's a great example. That's good that people can kind of hear that and understand that. Another question came in: what percentage do you feel of transactions have issues or litigation or anything that comes up, after closing or down the line? Like, how often does what you just said? I know you said once a month or so, but
yeah. So I'll give you the pitch. I guess it's an anti-pitch, but I tell you, I'm a horrible salesperson.
Yeah, that's you. I know.
and I do. People call me and say, "Do I need an attorney to review my transaction?" And I say 80 to 85% of the time, I look at everything and I don't need to make one comment. That it would have been just fine if I wasn't involved with the deal. But 15 to 20% of the time, I find something that would have been a significant issue had it been left unresolved at some point in the future, whether it was 5 years from now, 10 years from now, 20 years from now, when you passed away, when you sold the property, whatever it is. And that's why people come to me, not for the 80 or 85% where I just give them the confidence and the comfort level to move forward, knowing that they're going to be protected. But it's those other times where I see something and I say, boy, that doesn't look right, or you forgot to put the name of the marital status on the deed, or 3 deeds ago there was a problem. I want an insurance letter from the prior underwriter to make sure that if there's ever something that comes up that, that this guy was married when he sold it 2 deeds ago, if the spouse ever wakes up and files a claim, I want indemnity coverage from that old underwriter. And those are the things that make you feel better about having been involved and having watched it carefully to make sure that 15 years from now, I'm not going to get a call from somebody that says, geez, remember when I bought this property? Well, you should have caught this, or you should have caught that.
Hopefully for your sake, in 15 years, you're retired,
I'll be right here. 15 years.
Anybody else want to jump in with any questions about title insurance? Give it a second here. All right, gang. If not, we wish you a happy, healthy, safe, fun Labor Day. Enjoy. For everyone that got somebody back to school in the last couple of days, congratulations. Hope everybody stays safe. And we will resume after the holiday. So have a great one, Paul. Thank you, as always, on behalf of Trident Performance and Synergy. We appreciate it, guys. Have a great one. Thanks, Paul.
You too. Bye-bye.
Bye, guys.